Tell us about the types of hearings that happen in immigration court.
Types of hearings in immigration court typically deal with asylum applications. The next one is cancellation of removal for both legal permanent residents and non-legal permanent residents. The other application that's typical in immigration court is the adjustment of status, where someone is applying for a green card before the immigration judge. There are other hearings that we call removability hearings. The immigrant or the respondent could be challenging the charges in a notice to appear. And so the judge will adjudicate and see whether the government has proven their case to make someone removable. And so that's another very common hearing. And finally, bonds. I mean, immigration judges used to review bonds in large numbers. Now that scope has been dramatically reduced, and we'll go into that later on. But in a nutshell, those are the types of hearings that you see, the types of matters that you see in immigration court. Of course, asylum is the case where the respondent or the immigrant has to prove that they have suffered persecution on a protected ground, such as race, religion, nationality, political opinion, or that they're being persecuted on account of what we call a persecuted social group. And the burden of proof is on the immigrant to show this. With respect to cancellation of removal, here the immigrant has to prove to the court that they have qualifying U.S. relatives or legal permanent resident immediate family members, that they are a person of good moral character for at least 10 years going back, that they qualifying relatives will suffer extreme and unusual hardship if you are deported. You have to prove that. And of course, you have to show that you have lived continuously, physically in the United States for 10 years up until the notice to appear has been filed. So if you can prove to the judge's satisfaction that you're a person of good moral character, you've lived continuously for 10 years preceding the notice to appear, that your family members, the immediate qualifying U.S. citizens or legal permanent residents, will suffer extreme and unusual hardship, then you can be granted a green card before the immigration judge. That doesn't mean that the burden of proof is easy. This is a challenge, getting the documentation, and we'll get into this later, withstanding the Department of Homeland Security attempt to establish whether you are a credible witness or not. But cancellation of removal is another way for someone to apply for legal permanent residency. And of course, adjustment of status before the immigration court is another way that someone can apply for legal permanent residency.